And therefore, we know very well that based on the examination in chief of one of the witnesses by Safaricom PLC, who was PW5, they admitted to giving information without a court order, and that was an admission of liability, in fact, and therefore we will be vigorously and zealously representing our clients in the few coming days. That's it.
Of Mr. Mokaya to represent him as he seeks the compensation for the violation of his rights. As you might be well aware, he is a gentleman that was arrested on the 13th day of November 2024. He has had to endure for a period of about a year or so the vigorous trial before the Honorable Court here at Milimani Law Courts, pursuant to charges, flimsy charges that were levied against him. Now, after his trial, on the 19th day of February 2026, we've had to do a small postmortem so that to identify what led to his arrest, to identify, the gains that comes with the disadvantages that he was placed in during the period of time that he was enduring the trial. Well, after the postmortem was conducted, we realized that pursuant to an admission made by one Mr. Hamisi, an officer from Safaricom PLC, who was called as a fifth witness for the state, there was an open admission that the arrest of Mr. David Mokaya on the 13th day of November 2024 was actually instigated by Safaricom PLC without any lawful authorization. This is to mean that acting on a letter written by the DCI and without any lawful justification, Safaricom PLC led the investigative agencies to the location or the house of Mr. David Mokaya that led to his arrest. Well, we are a constitutional democracy. Safaricom PLC is not above the law. The DCI is not above the law. All of us are subordinate to the Constitution of the Republic of Kenya, promulgated on the 27th day of August 2010. And for that reason, through the instructions from our client, we have decided to call Safaricom to order, if not for Mr. David Mokaya, but for the sake of the posterity of this country. So that moving forward, Safaricom PLC will not be acting as or in the manner that they did, thinking that they can be greater than the Constitution, while it is the Constitution that has given them a space to thrive commercially within the Republic of Kenya. So for that reason, we have filed a constitutional petition before my lords in the Constitutional Division, inviting the Honorable Court, by looking side to side, the decision that was rendered by the Honorable Magistrate's Court that led to his acquittal, the preponderance of evidence that was presented by the state during the time that he was facing prosecution or persecution for that matter. We have invited the court to interrogate the evidence and the material and arrive at the conclusion that indeed Mr. Mokaya, David, being a citizen of this country, is entitled to certain rights and fundamental freedoms. One of them being the protection of his right to privacy. And we have also invited the court that after making the determination that indeed he is entitled to the right to privacy, that indeed his right to privacy was violated, and it was violated without any lawful order, which has been admitted before the Magistrate's Court. So we thought that it will be in their best interest to accede to our invitation for an out-of-court settlement in this matter. But lo and behold, they declined the invitation. We have just received a letter through our senior, Mr. Danstan Omari, Safaricom declining the invitation for an out-of-court settlement.
Right at man letter, and this is the response from Safaricom. It's a letter dated 24th February 2026. Re-demand notice dated 19th February 2026. MCCR /A1161/2024. Hard versus David Mokaya. Safaricom writing, we acknowledge the receipt of your letter dated 19th February 2026. Having reviewed the judgment made on the 19th February 2026, Safaricom does not admit and expressly denies any liability as alleged. We draw your attention to the fact that the trial court made no binding determination of civil liability against Safaricom. Further, we are of the view that observations in the judgment concerning investigative practices cannot be construed as imposing strict constitutional liability on a telecommunications provider acting in compliance with formal requests from law enforcement agencies. Any suggestion to the contrary is misconceived. This in mind, your ultimatum requiring Safaricom to accept liability and offer compensation within 48 hours, including the asserted figure of Kenya shillings 200 million, is unequivocally rejected. This response has comprehensively addressed your concerns, and any litigation will be vigorously and robustly defended. Yours faithfully, Ongeshi Gishuki, Head of Department Legal Services for Safaricom PLC. That was the response to Mokaya's demand. Safaricom has called a judgment of a court as mere suggestions, because Safaricom is the bigger judge of this country. Safaricom has arrogated itself the purposeful decision to disclose personal data of citizens of this country and any foreigner of this country. Safaricom was there when the Data Protection Act was being made. If they wanted, they could have lobbied Parliament to say Safaricom can disclose any data to anybody without a court order. The act is very, very clear. Only through a court order. The reason why the police come to court under miscellaneous application to get a court order to seize gadgets of people is because they are in compliance with the court order and with the law. They admitted that they gave information of the whereabouts of Mokaya without a court order. Safaricom has been cheated that Mokaya will go to the Data Commission, where the maximum is 5 million shillings. This is a constitutional violation. This is an affront on the Bill of Rights. This is an affront on the marginalized group like the Gen Z, who are almost 3/4 of this country. We are determined. They have said they will defend robustly. We are filed. We will prosecute viciously, and we shall be calling upon anybody who has been aggrieved by the action of Safaricom to come to us. We shall pursue this matter because this is about the safety, security of young people and citizens in this country. The police know very well they do not have rights to access the telephones and data of any citizen of this country without a court order. But Safaricom is defending an act that is illegal, an act that is unconstitutional, an act that violates the primary consideration of the privacy of any citizen. It is the only entity, no bank, has ever given the police information without a court order. No entity in this country All of them you must have a court order, except from Safaricom. Safaricom has decided to enter into a boxing ring with Mokaya. We will see he who loves last, loves best. Mokaya was traumatized. He was picked as a petty thief, put in the Subarus of the DCI, transported from Eldoret, a distance of over 350 kilometers, inside a police booth. This young man has seen it all. But this is going